So we're going to talk about 5 things. We're going to talk about exactly what is a trademark and the different sorts of versions that you might be able to register, why you would want to register your trademark with the USPTO, how to select or choose or create a strong trademark. And I'm very briefly going to hit on filing and registration, and then I'm going to finish out with other places to find help. Now, I see, Brian, I can see you, and it looks like you're taking notes, which I love. Just to let you know, you're going to get a copy of these slides, so don't feel like you have to jot down every single thing as I go through, because you will get a copy at the end today. So next slide, please. All right, so next slide. Okay, so first of all, what in the world is a trademark? Now, I think we probably all sort of know what it is. Like, for example, if I said BMW, what do you think of? Cars. If I say Coca-Cola, what do you think of? Soft drinks. Levi's, jeans. Nike, shoes. Budweiser, beer, right? So every time we see or hear a trademark, we're talking about pretty much a brand name, it is automatically calling to mind a particular good or service. And legally, that's what we're talking about. It's any word, symbol, design, or combination of these that does 2 things. It identifies the source of goods, and it distinguishes them from the goods of another party. And so, you know, as everybody's able to get out and about now, maybe go to restaurants for the first time in a long time, if you go and sit down and the waiter comes over, says, "Would you like something to drink?" And you say, "Yes, I'd love a Coke." And he says, "Is a Pepsi okay?" That is a trademark in action. It is identifying the source of the goods that they provide, which in this case is Pepsi, and it's distinguishing from another soft drink, which would be Coca-Cola. And so it's very important that we always keep in mind when we're talking about trademarks, it's not just a cool word or cool slogan or a cool picture or something like that. It is always, always, always tied to very particular goods or services. Next slide, please. Now, notice that I said that it's always tied to goods or services. Technically, the word trademark encompasses both trademarks and service marks. So trademarks indicating the source of goods, service mark indicating the source of services. But really, it's not something that you have to worry about. You can just refer to it as a trademark or even a mark, and it's totally fine. Actually, today, I will probably refer to it as a mark more than anything else. Next slide. So when you... So the way it works, so you as a business owner would have a trademark that you use to indicate the source of your goods and services. If you decide to register your trademark with us, you'll have various options in terms of the version of the trademark you want to register with us. So let's say you're Coca-Cola, you would have the option, if you wanted to register the word Coca-Cola alone, right? Which is an incredibly broad scope of protection, because it means over the life of the trademark, you can have your wording appear in whatever font, style, size, or color you want to. You're not specifically locked into it appearing in a particular way. And this is really great when you think about how long a business might be in operation. You know, Coca-Cola has been around since what, the 1800s. So probably over the time, yeah, they're going to change up how their mark appears a little bit. So if you register the word mark version, we refer to it as a standard character format. In that case, it's going to give you an incredibly broad scope of protection. And as you can see here, a slogan is also registrable. In this case, Coca-Cola registered "It's the real thing" through that word mark, that standard character mark, which means they can use it in whatever font, style, size, color they want to over the life of the trademark. So now some of you might be like, well, that's fine, Jason, but I actually have a really cool logo, or I've got some cool graphic stuff that I do. That's fine. You can absolutely register that as a trademark or as part of your trademark. You can see there the stylized, composite, and design marks. Those are typically known as what are, they're typically called special format. And what that means is that there is some additional element. It's not just the wording that you're protecting, but it's also how it appears. Now, that's great because you're getting protection for that appearance, but it's also a little bit limiting, because that also means over the life of the trademark, technically your legal protection is only for how it appears in your registration. Right? So let's say Coca-Cola registered the stylized mark there in their font and in the color red. Technically, it would not cover it in green if Coca-Cola wanted to use it in green on St. Patrick's Day, right? So it's limiting it to being in that color and in that font. So that is why the word mark or the standard character format mark is so powerful is because it protects them regardless of the color that it's in or the font style that it's in. Now, you'll notice that I said it's limiting to color. So I'll tell you now that you have an option to register your special form marks in black and white, which means that you're telling the office, hey, I'm not claiming a particular color. Which is great because that means over the life of the trademark, you can use it in whatever color you want to, and your registration is not necessarily limiting you to a particular color. So in the composite mark down in bottom left corner there, in that case, if that was in black and white, technically Coca-Cola would be covered if they put it in purple and orange and pink, right? Instead of the blue and the red and the green and all that sort of stuff. Next slide. All right, so those are the traditional types of marks that we really think about. We think about brand names, slogans, and logos. But the cool thing is that pretty much anything can be a trademark so long as it indicates the source of goods and services. So if you think about sound, like the NBC chimes, bum, 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 or the MGM lion before a movie, or think about colors like the fluorescent or hot pink in insulation that you might have in your home, or a Tiffany blue box. Those are pink and blue, those are all registered trademarks. Same with brown on the side of a parcel delivery truck. You might see trundling down your street. UPS has registered brown for use on those things. And so you know when you see that truck, oh, that's UPS. Right? So pretty much anything can be a trademark so long as it indicates source. Next slide. So, okay, now that we know what a trademark is, we want to talk about why you might want to register your trademark with the USPTO. Next slide. So this is a place where sometimes folks do get confused because they think they have to come to the USPTO in order to buy a trademark or to get a trademark or even select a trademark. Because it's different than say a domain name registrar where like when you log on, you're like, oh, let's see what's available. That one's free. I'll take that one. That's not exactly how it works. It's a little bit different here because in this case, you as a business probably already have your trademark. And so then the question would be, do you want to go and register it? So as you can see, the rights are created two ways. One is under common law and one is under federal registration. Next slide, please. Under common law trademark rights, you begin to create rights in your trademark as soon as you begin to use it. This is typically based upon state law, might be a statute or case law, things of that sort. And so as soon as you start to use your trademark, you are gaining rights. You are building rights in your mark through use. You might be using the TM or the SM after it. Those are common law trademark indicators. You see that all the time. You might even have it on your slogan or on your logo or your brand name. And it's totally fine. You can use those anytime you want to. And it's a great way to put the public on notice. Hey, this is my trademark and I'm claiming it and I'm using it as a trademark. Now, the problem, as you can see here, is that common law trademark rights are limited to the geographic area where the mark is being used. So if you are only using it, say, in New Hampshire, then your rights would only be in New Hampshire, right? So if you wanted to expand your rights or you were planning to expand your business, all right, then you would want to make sure that you have protection for your rights across the country. And the way that you are able to do that is you federally register your trademark. Next slide, please. So when you start to use your trademark across state lines or between your state and a territory or between your state and another country, you are using your trademark in what is known as interstate commerce, right? Just inside New Hampshire would be intrastate, so across state lines would be interstate. In order to register, you must be using it in interstate commerce. So when you're doing that, you could, once you are using your trademark in interstate commerce, you register it with us. And your federal rights are then created. It creates a legal presumption that you own the trademark and that you have the right to use it throughout the United States and its territories. Next slide, please. You're putting public on notice of your nationwide rights. Essentially, you're being put in our database of applied for and registered trademarks, which means that anybody in the world can actually look in our database and see, oh, yeah, I see, that's Christine's trademark. Yeah, wow, okay, cool, right? So I better not use that because I know she's really litigious and she's gonna come after me and sue me, right? So you can also bring a legal action concerning your trademark in federal court, which is really great, because what if you've registered your trademark and you're going along, and all of a sudden you hear that Christine's candles out there in somebody in Oregon has created this thing. Oh man, Christine has her own Christine's candles in New Hampshire. Well, if you didn't have that federal trademark registration, then you would have to go there to sue her and stop her from using it, right? For trademark infringement. But with that federal registration, you don't have to do that. You can actually stay home. You can go to the federal courthouse that's nearest to you, and you can sue that Christine's Candles in Oregon and make that person come to you in order to defend. And that's a really great benefit. You can also record your registration with U.S. Customs and Border Protection, which is fantastic if you are operating in an industry where there's lots of counterfeit goods. Think about clothing and electronics and fragrances and masks and PPE and hand sanitizers, things of that sort, as we've discovered in the past year. So if you're in one of those industries, then it's quite possible infringing goods or counterfeit goods might be entering through the ports. And so CBP, once you record your registration with them, can work to stop those goods from entering the country. And next slide, please. You can also use your registration as a basis for filing in another country. It's called an extension of protection, and you are extending your rights outside the United States and into, say, Canada or Mexico or any of the other countries that we have an agreement with through the Madrid Protocol. Now, I have to tell you that, okay, so first of all, remember, your rights in the United States are only in the United States, okay? There is no such thing as an international trademark registration, right? And there's nothing you can just file here and then be protected around the world. That's not the way it works, because every country has their own laws and they have their own specific trademark laws. So if you want registration in Canada or in Italy or in Nigeria or in Japan or wherever it is you want to be operating, then you have to make sure you're protecting your trademark rights in that country. So the Madrid Protocol is a great way of going about that. Now, I will tell you, it does cost money, right? Of course, because everything costs money. There's different filing fees and things of that sort. And also the cool thing about registration is you get to use the R in the circle symbol, which is of course what everybody wants, right? And because that's the gold standard in trademarks, right? You want to be able to use that R in the circle at the end of your trademark. So with registration, you are allowed to do that. So next slide, please. All right, so now we know what a trademark is, right? It's a brand name, a slogan, a logo. We know why you would want to register that with the with the USPTO in order to get those nationwide rights. Well, let's talk about how to select or choose or create a strong trademark. Next slide, please. All right, so as I mentioned, when we're talking about trademarks and people have that misconception that you get a trademark at the USPTO or something along those lines, there's also a misconception that if you have a trademark, then it means that you are the exclusive owner of that phrase or of that word and no one else can use it. And if they use it, then they have to pay you a nickel. Yeah, that's not exactly right. And I'm not saying that you guys think that that's the case, but I've heard it before where people have said that. But it's not really what we're talking about. So you don't have exclusive ownership of a particular word or phrase. What you have is the right to use that particular word or phrase or other trademark in association with very particular goods and services for use as your brand. Right? So that's a little bit different way of thinking about trademarks than sometimes folks have an understanding of it. So, but it's very important that you understand that because you have to understand that not every trademark is going to be registrable. Now, as the USPTO, it is our mission to register trademarks. We want to register trademarks. We would love nothing more than to be able to register your trademark. But actually, that it doesn't always happen. There are reasons why a trademark would not be registered. So you want to make sure that your trademark, before you try and register it, is the sort of trademark that can be registered with our office. And the other thing you want to think about is you want to make sure that your trademark is going to be legally enforceable once you do register it. And the first time I realized that might be an option, that you would not be able to enforce it, it sort of blew my mind. But then as I thought about it more, I was like, oh, that's right, because of common law trademark rights. Common law trademark rights are based on use, right? So you could have a situation where somebody has been using a trademark for an incredibly long amount of time, and they have never, ever, ever registered it with the USPTO because you don't have to. There is no rule, no regulation, no law that says you have to register with us. It's just whether you want to avail yourself of the benefits of federal trademark registration. So you could be in a situation, let's say Coca-Cola never, ever, ever registered their trademark for Coca-Cola. And you're like, oh, I see an opportunity here. I'm going to register Coca-Cola for soft drinks. And then and the USPTO says, oh, okay, there's no USPTO registered. It must be you. Okay, go ahead. Right. So you have your registration for Coca-Cola for soft drinks. And all of a sudden, Coca-Cola says, whoa, whoa, whoa. No, 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 no. And they're going to cancel your trademark. They're going to sue you, among other things. And they're going to cancel your trademark registration because they have prior rights. Right. So we want you to avoid that situation where somebody comes out of the woodwork and says, whoa, 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 I already have trademark rights. And so all of a sudden, all that time and effort that you spent getting your trademark registered goes out the window. So I would like to put you in a position where you are selecting a trademark or choosing a trademark that is federally registrable and legally protectable. Next slide, please. And there are two main concepts that are going to go a really long way to helping you get there. First is likelihood of confusion, and the second is understanding strength of a trademark. Next slide. So for likelihood of confusion, really what we're talking about here is you often hear referred to as trademark infringement. Oh, somebody's infringing on my trademark. Like it's too close to my trademark. And what we're talking about here is the fact that people would be confused when they encounter both of your trademarks in the marketplace. So let's say we have Christine's candles, right? And they're sold at fine retailers near you, right? So you walk into the store and you see Christine's candles there on the shelf, and next to it is a Christine's candles, but instead of being spelled with C's, it's spelled with Q's. And you're like, oh, interesting. It's Christine's candle. I'm sure it must be the same thing, right? It's Christine's candle. It must be the same thing, right? So you get confused and you don't realize that it's actually her competitor who's been trying to use a similar trademark to hers. So what we're talking about here is that you as a consumer are confused as to the source of those goods or services that you are purchasing. And as you can see, we really boil it down to a two-part test. And you're looking to see, are the trademarks confusingly similar? And are the goods and services related? And those are two prongs of that test. Both prong has to be yes in order for there to be a likelihood of confusion. So when we're talking about similarity, when we're looking at trademarks, we're talking about, do they look alike, sound alike, have a similar meaning or a similar commercial impression? And for the goods and services in terms of relatedness, really the question we're asking is, does one company typically create both of those goods? Or does one company typically provide both of those services? And if the answer to both of these is yes, then there is a likelihood of confusion. And if that is true, if you have applied for Christine's candles, right, and the trademark examining attorney looks in our database and comes up with a Christine's candles for candles, but it's spelled with Q's, that could be a problem. And her application would be refused because of a likelihood of confusion with a trademark that is already in our database. So, and I'll just point out before we move on to the pop quiz that I'm going to give you, is please note that it's not identical. Okay, the trademarks do not have to be identical, and the goods and services do not have to be identical. We're talking similarity and relatedness. And the other thing I'll say with regard to identical trademarks is it is absolutely true that trademarks that are absolutely identical can coexist in the marketplace and on the register so long as those goods and services are unrelated. So think about Dove. So if I say Dove, you might have immediately thought of soap, or you might have thought of ice cream bars, right? And for the most part, that's going to be fine, because as consumers, we're not going to think that the company that produces soap is also producing ice cream. Now, I understand there are, international conglomerates that do that sort of thing, but they're not using the same brand on both, right? So, because the last thing you want to do is bite into a chocolate dipped soap bar, right? So it is true that identical marks can exist in the marketplace, but the goods and services have to be unrelated. Next slide. All right. Typically I do a pop quiz here. Maybe I won't, I'm not going to do it today, I guess, but maybe I will if we have time. I'll put it in the chat or something like that and see whether you guys think there's one. All right. So in order to look to see if there is a likelihood of confusion before you apply to register your trademark, we always suggest you do a clearance search. You want to clear the area around your trademark to make sure that there's nobody else out there using a same or similar trademark for related goods and services. And there are two things that we suggest that you do. The first is to look in our database using the trademark electronic search system called TESS, T-E-S-S. And you can follow the link right there, and that'll take you to the webpage where you can take a look at TESS. I'm going to tell you right now, it's a little bit of a tricky system to operate. So it's been around for about 20 years, and the operating system hasn't really been updated since then. So as you might imagine, it's not as easy as Google, right? That is something that we're currently working on updating, but it's not there yet. And I can talk to you more about TESS if you want to. And actually tomorrow we have a Trademark Basics Bootcamp that we do. And tomorrow's session is actually about using TESS. I take you into the system. I show you searching mechanics and things like that. I'll show you the link for the Trademark Basics Bootcamp later on, if that's something that you think you'd be interested in signing up to learn about. So in addition to looking at our database, we also recommend you look online. Right? You want to check Google and Bing and Yahoo and see, is anybody else out there using the same or similar mark for related goods and services? Next slide. Now, if all of that feels like too much and you're like, Jason, I do not want to do all of that, well, we also recommend you might want to hire a private trademark attorney, because the trademark attorney can do a full-on clearance search for you. She can look in the database, our database, and state trademark databases, foreign databases, business name databases, all that sort of stuff. Maybe even hire a trademark search firm. Anybody can hire one of those, but the issue is you have to do the analysis yourself. Right, so you need to really know what you're doing when you're doing that analysis. Are these trademarks similar, and are these goods and services related? It's both a science and an art. So sometimes it's helpful to have an attorney help you do that. And I understand attorneys are expensive. Yeah, I get it. So we can talk about some free and reduced price legal services that are available that you might want to look into. If you want to hire an attorney, but you're like, Jason, my checking account just won't hack it. So we can talk about some options for you. Next slide. Okay, so that's likelihood of confusion, right? You want to avoid trying to register a trademark that is going to cause confusion with somebody else's. The other thing to think about is the strength of your trademark. Now, as you can see on the screen, I have it set up here as a temperature gauge that goes from weak to strong or cold to hot. It's sometimes referred to as the descriptiveness spectrum, but I think that the temperature gauge is more illustrative, let's say. And so really what you want to do is make sure that your trademark is in that fanciful, that arbitrary, or suggestive range. Next slide, please. So when we're talking about fanciful and arbitrary trademarks, these are the strongest types of trademarks, and they're inherently distinctive. If you look there in fanciful trademarks, those are marks that have no meaning in English or in any other language. They're made up words like Xerox and Kodak and Exxon and things like that. Now, we know as consumers, when we hear those things, we can automatically think of photocopiers or cameras or petroleum, right? But when they first came out, that wasn't the case. But we have learned as consumers that they indicate source, which is really great. And a lot of other people are going to have trademarks that are similar to those. So you're not going to have as many problems when you're thinking about likelihood of confusion. Same thing with arbitrary trademarks. These are also very strong. Now, arbitrary trademarks have meaning in English, but no relationship to the underlying good or service. So apple, a common word that we all know as a fruit, but it has been registered for computers. And actually today, when we hear the word apple, we probably don't think of the fruit all that much. We think of the computers and the phones and watches and all that sort of stuff. Gap for clothing. Clearly has meaning as a space between two things, but it also has meaning, now we know, as a clothing store. BlackBerry for mobile devices. Right? So fanciful and arbitrary marks are great marks, and they are inherently distinctive and very strong. Next slide, please. Now, a little bit colder, perhaps, than fanciful and arbitrary marks are suggestive trademarks. They suggest something about the underlying good or service. So copper tone for suntan lotion, it doesn't tell you that it is suntan lotion. It kind of suggests that if you use their product in the sun, your skin may take on a coppery tone, right? It's not bronzer for suntan lotion, right? Or bronzing lotion or something like that. It's copper tone. So there's a little step there, a little mental hitch. They're like, oh, yeah, okay, yeah, no, I can see that. Okay, I got it now, right? And so those suggestive marks are also inherently distinctive. They are registrable on our register. So those are great places to think about your trademarks: suggestive, fanciful, and arbitrary. When we start talking about descriptive marks, it's a little bit tougher here. These technically are not registrable on our principal register. It is possible to register them. They will be refused straight out the gate, just so you know, okay? So they will be refused. It is possible to overcome that refusal by jumping through a couple of hoops, and if certain things are true, but they're tougher to register, and even if you do register them, they're going to be harder to protect. Now, a descriptive mark describes something about the goods or the services. As you can see here, creamy whip for whip topping. Creamy whip is not really functioning as a trademark, right? Is not indicating source. It's just telling you that the whip in the container is creamy, all right? So it's not indicating source. It's just saying, hey, if you buy this, you're going to have some whip that's creamy. And probably everybody who is making whip topping wants to talk about their whip being creamy, because nobody wants chunky whip, right? It's you always want it to be creamy, right? To put on your pie and things like that. Or your ice cream. So creamy whip is not really functioning as a trademark because it is describing the goods or describing the services. Generic, well, those aren't even trademarks at all. They're just the word for the thing, right? Milk for a dairy-based beverage is not indicating source. It is just telling you what the thing is. It is a dairy-based beverage. Milk will never, ever, ever be able to register for a dairy-based beverage. Same thing with bicycle for bicycles. It's just telling you what the thing is. Now you might say, well, Jason, bicycle is a trademark. That's right, it is. It is registered for playing cards and casino services and things like that. And that is because it is functioning in that way as an arbitrary trademark. It has meaning for bicycles, but no relationship to the playing cards or casino services. Right? So that's sort of how that works. So I want you to focus as a business owner, try and focus and think about your trademark being on the suggestive, fanciful, and arbitrary side of things. Next slide. Okay, so we know what a trademark is. We know why we want to register it. We know a couple things about how to select or choose a strong trademark. I very briefly want to talk about filing and registration, and then we'll get into help, and then I'm going to answer as many questions as I possibly can. Okay, so next slide, please. So in order to register your trademark with us, you need to do two things first. First of all, you want to do that search. Always remember to do the search. But after that, you need to create a USPTO.gov account. It's just like any other account that you create on any other website in the world, because everybody has to have an account now. But this is true because we are really focusing on privacy and security. So we want to make sure that you are who you are, and you are the person who's supposed to be filing the thing in the application that you're supposed to be filing. Okay. And the other cool thing about it is that it creates sort of an intellectual property portfolio for you at the office. So if you have various trademark applications and registrations or patent applications and patent grants, all of that is going to be accessible to you through your USPTO.gov account. So you need to create one of those accounts, and then you would use the Trademark Electronic Application System called TEAS to file your application. And if you're getting close to that phase and you are thinking you're going to be filing pretty soon, but you're not really sure, then we have a couple of Trademark Basics Bootcamp sessions that are coming up that speak specifically to this topic. We have one that's about application requirements, and then another one where I actually walk you through the form and say, oh, if you're this, then you click here. If you're that, when you click here. So that's how you would fill out the form, is using TEAS, and you have the option of TEAS Plus and TEAS Standard. Next slide. So as you can see here, your filing option is going to affect how much you pay. Oftentimes people will be like, Jason, how much does it cost? Well, it depends, right? And so, which is pretty annoying. I understand that. But actually the filing fee is based on various factors. As you can see here, the cheapest is $250. And that is to register your trademark in one international class. Now, remember, I said there's no such thing as an international trademark registration, but there are international classes, which really just means that we, the United States, have entered into treaties with other countries around the world, and we've all agreed that goods and services are split up into 45 different international classes. Clothing is in one, certain beverages are in another, different food is in another, paper products are in another, chemicals are in another, metal is in another, right? Services, retail store services are in one, restaurants are in another, right? So it's all sort of divided up that way. So as you might remember, trademarks are always, always, always tied to particular goods and services. So in your application, you will have to say, oh, I'm registering Christine's Candles for candles. And you would have to identify candles in your application, and candles would go into a particular international class. And so if that's all you're trying to register, well, that'd just be $250. But if you're going to register candles and you're like, oh, but I also want to register Christine's Candles on the various merchandising swag that I sell, so I want to put it on, I want to register as a brand for my t-shirts and my sweatshirts and things like that. Well, clothing is in another international class, so it would be $250 times 2, because you are trying to register it in 2 international classes. So that's kind of how, a real brief sort of primer on terms of how filing fees would work. Next slide. Now, we're not going to go through the different things that you'll want to think about before you file. As you can see here, this is our pre-filing checklist. Along with the slides, I'm going to make a note right now. I'm going to include this along with it, a copy of this along with it. You can download this, and it has sort of like the 4 things that you want to think about in terms of your mark type, your ID, your filing basis, and then choosing your application form. So hopefully you'll find that helpful. And also, as I said, we're going to talk about these things in the boot camp over the next couple of weeks. So next slide, please. So once you do register your trademark, keep in mind that you still have to continue to do stuff with it. All right. You have to continue to use your trademark in commerce and file your post-registration documents. Those are due at particular times. So I'll talk about those on the next slide. The other thing you have to keep in mind is that you have to, I'm sorry, that was really confusing, Christine, my fault. Coming up, I will talk about those things. But you also have to remember that it is up to you to enforce your trademark rights. There is no trademark police. We are not an enforcement agency. So you as the trademark owner are required to do your own enforcement. And that's also why it's so important. You might want to think about having an experienced trademark attorney in your back pocket to help you in those situations. So next slide, please. Okay, so with regard to those post-registration documents, just keep in mind the first one is due between the 5th and 6th year after registration. The second is due between the 9th and 10th. And then every 10 years thereafter. So there is no sort of like expiration, unlike a copyright or a patent that sort of goes away after a number of years and goes into public domain. That is not the case with a trademark. It's a completely different type of intellectual property, and a trademark and a trademark registration can last forever so long as you continue to use your trademark in commerce and file your required post-registration documents. We obviously don't have time to go in deep on these, but in week 7 of our bootcamp, we do. So if this is something you're like, oh yeah, I have a registration, oh, I don't know what's due, be sure to sign up for week 7 of our bootcamp and you can learn more information there. Next slide. And another quick reminder that all information in your application file does become public. And that is, the law says we have to make the information public. And so what happens is private companies scrape our database and they pull information. They're like, oh, look at this. This person is not represented by an attorney. Let me try and scam them. Okay, not everybody. Some solicitations you get in the mail will be legitimate, but there are a lot of fraudsters that are out there that are trying to scam you into paying money that you do not need to pay. We are limited as the USPTO in what we can do to stop that. So we're trying to educate as much as we possibly can. So if you click on the link when you get the slide deck, That'll take you to the webpage on trademark solicitations. There's a huge, big list of examples of all the different fraudulent things you might get in the mail. So if you get one in the mail after you've applied and you're like, huh, this is weird. The USPTO appears to be asking me to pay 4,000 euros for some private trademark registry in some country. Well, that doesn't make sense, right? Well, you can probably look on the web page there and see, oh yeah, that's right. That's somebody trying to scam me. I can rip it up and throw it away. So we always recommend that you do check it against the trademark solicitations page. Or the easy thing too is that once you have an application going in front of the office, you'll have an 8-digit serial number. You can type that 8-digit serial number into TSDR, the Trademark Status and Document Retrieval System, and you can look in your case and you can see every single piece of information that's in your file. And you can look in there and say, did the USPTO send me anything that's asking for 4,000 euros? I'm looking in there, I don't see anything. No, okay, cool. Rip it up and throw that thing away. Next slide. Okay, so we know what a trademark is. We know why you'd want to register one. We know a little bit more about a strong trademark. We know a little bit more about filing and registration. Let's quickly talk through help, and then I'm going to answer questions. So next slide. All right, we have a ton of great information on our website. So USPTO.gov, click on trademarks. And in particular, I would say take a look at Trademark Basics. We recently redesigned the page. There's a lot of new and really good information there about a lot of the stuff that I talked about today. We also have our downloadable Basic Facts About Trademarks booklet. We also have trademark videos. Unfortunately for you, you're going to see me in most of them and my big old shiny forehead. And so, we have different ones that are about basic facts, ones that are from our news broadcast style series called the Trademark Information Network. And we also have some that are from our T's, Nuts and Bolts video series. So when you're actually filling out the form, you can click on a 1 to 2 minute video for that page. And it's, again, my voice telling you, if you're this, click here. If you're that, click here. So lots of great information available for you on the website. Next slide. And of course, we have our Trademark Basics Bootcamp. Right now, anyway, we're running it essentially every single Tuesday throughout the year at 2 p.m. Eastern. We are just new into this current cycle. This is week 3 coming up tomorrow. As I said, that's about searching in tests. And then we talk through the application over the next couple of weeks. Then we talk about how to respond to an office action. And then we talk about post-registration. And then we finally, in the final week, we have a Q&A session where we have experts from the office on the line. You can ask any question you want to about trademarks, and they will do their best to answer it. So we always recommend that if you're interested in going deep on more of the subjects we talked about today. Next slide. The Trademark Assistance Center is great. They're our customer service division. You can give them a call. They're open 8:30 a.m. to 8 p.m. Monday through Friday. That's East Coast time. They typically pick up within a couple of rings. I think by 2 rings is the industry standard for them. Email might take a day or so to get back to you, but they're really great about giving you additional information. Now, they cannot give you legal advice. No one at the USPTO can give you legal advice, but they're a great resource for learning more information and finding things. And hey, where's this on the webpage? Oh yeah, you go over here, that sort of stuff. Next slide. Just as a reminder, we do not enforce your legal rights, and we do not give you legal advice. And that is why we do recommend you might want to think about a private attorney to help you. Next slide. Okay. So we're in the questions. We got like 8 minutes. Before we get to that, I do quickly want to mention one thing, and that is our law school clinic program. For those of you who are interested in free and reduced price legal services, we have partnered with law schools around the country, about 60 of them at this point, and more will be on the way soon. And essentially, if you qualify for their program, you apply, and if they take you on, you will get your trademark work done for free. You are going to be working with a trademark attorney who knows what she's doing. She's probably the teacher, the professor for the clinic, things like that. And you'll also be working with a law student. So the law student is going to be learning while you're getting good information and good legal help for free. So just something to think about anyway.